All right, going first to
Your
number.
Honor,
Yes.
sorry, Stephen Swanson. I'm on number 8. I think we can just strike that because it was a review to see if the GL report was in.
Okay.
And it is in.
Okay. Hold on. Let me get to where I need to get to, and then I'll address that. First,
Thank you.
before we get anywhere, are there any agreed continuances? So I don't mind. I think we have. I saw the paralegal from Miss Looney's office. Are you on here?
Yes, I am, Your Honor.
Okay. Are you able to get a message to Miss Looney?
Yes, I can.
Okay. After I reviewed this last night, I agree. So Mr. Anagnostou, any objections to just striking this? And for the record, we also have Twyla Corey. I saw the report was filed, and I'm not sure there's anything else to do today.
No, council and I had an opportunity only this morning to talk, and we agree that this could be stricken, and further action would either be by motion or docket notice, or we'll go forward.
Okay.
Yeah, we intend to file a motion today or tomorrow. So
Okay. All right. So with that, now I can't remember where the individual is.
I'm still here, Your Honor.
Okay. All right. Thank you. If you could go ahead and let Miss Looney know that we went ahead and have just stricken this matter for today, and it was just the report was filed and there was nothing more to do.
Okay, I will let her know.
All right. Thank you. All right. We have Miss Winkles. We have Miss Dow. I don't know if we have Miss Turnbull. Okay, I don't see her. This matter comes on for a request by the petitioner, and I did not see a response from the respondent. So is there any objection?
Yes, Your Honor, and that response was filed. It was filed last Friday, I believe. This is on a shortened time, and we filed and served Ms. Winkles, I believe, on Friday.
Okay.
It should be in the record.
Takes a couple days to get things filed. So I haven't reviewed the declaration of Mr. Larson.
Does Your Honor
Well,
just want to set this over a week with that? I know today is a short docket, so it's kind of nice, but I don't know what your docket next week looks like. But if Your Honor would like to set it over, I think we're okay with that.
Okay, let me look. Okay.
And Your Honor, I'm available next week as well.
Okay. So, yeah, with that, I'll go ahead and set it over to the 20th, just because I want to make sure to read that. So,
Okay.
All right. So I'll set that over to February 20th at 9 a.m.
Thank you, Your Honor.
Ms. Dow?
Yes, Your Honor.
I just wanted to say that if you send something over for filing on a Friday, always send an email. I don't like emails as such, but at the same time, it's not likely to actually get into the Odyssey file until a couple days later. So just so you know that.
All right, Your Honor. Thank you. I appreciate that.
Okay.
Normally we don't send you emails, but
Yeah, no, and
I appreciate that. Thank you.
Okay, thank you. 08 Williams and Williams.
That matter's ready. I'm here.
Okay, if you want to come just right up there in front of the microphone.
Want me to move? Because I can move.
You're fine. She can sit over there.
And Your Honor, it appears that's my client, Sylvia Williams, in the courtroom today.
We have Miss Bliss online. Do we have Leonard Williams?
No.
I'll just have you remain quiet. Okay, no response. So with that, this was a motion to convert the legal separation into a final divorce order, ordering converting the legal separation to final like I say, final divorce order. So with that, Ms. Bliss, any information?
I did receive a phone call from Mr. Williams, on Friday. He did indicate that he did receive those documents. I did send him the Zoom link for purposes of today's hearing. His inquiry on Friday was, paraphrasing, of course, if I agreed, do I just give you signatures? We indicated yes. We resent him those documents via emails, and we have not received anything since then. It's my request of the court today to just sign my orders as is, since he has failed to appear, and given his discussion with my office on Friday, it seemed like he was inclined to agree anyways.
All right, with that information, not having received any response and Mr. Williams not being present today, I will go ahead and sign off on the order converting the legal separation to final divorce. Noting on here that Mr. Williams not appear. All right, I have signed off on your order.
Thank you, Judge. That's all for today.
Here's the order. Anyone else on that matter? Mr. Sasaki, any information?
No, according to our record, we have served notice of the hearing as well as the motion to compel on the opposing party, and I have not seen a response back. We've tried continuously to get a hold of the respondent for our discovery interrogatory and request for production, and he just does not respond.
Okay. All right, I did review the files and record. I noted all the dates that you've attempted to try to have a 26I, and that did not achieve anything. So what I'm going to do today, understanding that Mr. Neese has not responded, and just for the record, Mr. Sasaki, is your client online?
Is
Okay.
Jennifer Silverson.
Okay. So with that, again, not receiving a response from the respondent, notice was given. The court does order the respondent to respond to the interrogatories and requests for productions no later than March 1, 2024. In addition, the respondent shall pay $1,500 in attorney's fees for the failures to respond to the attorney for the Civil Rule 26I requests. And then I will set a review date on March 5, 2024 at 9 a.m. If the respondent has failed to respond, then the court will look at the idea of striking the pleadings of the respondent and grant a default to the petitioner.
Understood. Thank
Okay.
you. May I drop that order?
Yeah, if you would, and just for his signature, note did not appear.
Good morning, Your Honor. Ann Margraf on behalf of Ryan Larson.
Noel McLean on behalf of the petitioner Athena Larson.
So Ms. McLean, I received your email about where you're at this time. Just listening to you hurts. So I looked at everything at the same time. I was also thinking I'd like a little bit more time to look over the proposed, what you had as the proposed parenting plan. So with you not feeling well, if nobody has an objection, so I was thinking of setting it over a week. Does that work for everyone?
Checking my calendar.
Yes.
That would work for us. Thank you, Your Honor.
Okay. All right. I'll go ahead and set this over to the 20th at 9 a.m.
Thank you.
Your Honor, I submitted documents yesterday. I served hard copy on both Your Honor and Mr. Anagnosio, and I also sent emails. I also served the proposed orders from the last hearing plus the proposed order on the protective order.
And I've only had an opportunity to briefly scan these documents. I haven't had a chance to prepare a response. I do have a request of the court, and that is that this is not a divorce action. This isn't a divorce. This is a post-divorce modification of the parenting plan. So all these complaints about, bank records and all that stuff, it doesn't even apply.
Well, Your Honor,
Hold on,
Well,
hold on.
I'm frustrated okay, I'll stop.
Excuse me, Your Honor, we're here on one matter. If Mr. Anagnostou has a separate motion, I would ask that he do it in writing. We are here strictly for the purposes of reviewing the discovery and entry of those two orders. So my response was strictly to the lack of discovery. I understand that I just served Mr. Anagnostou, but I had a week to go through, and I'll show Mr. Anagnostou this pile to see what was missing. And so I did the best I could, as fast as I could. I had other hearings in juvenile. I couldn't get it done any sooner. So it wasn't an attempt to shortchange Mr. Anagnostou or the court. Just needed to review the information.
So let me address first the protective order. I believe this was one matter that was clear. So Mr. Anagnostou, are you okay to put approved via Zoom on that?
Yes, Your Honor, we talked about that last hearing. You were going to enter the protective order prepared by Miss Kudo with my interlineation.
I didn't put Mr. Anagnostou's specific interlineations because I didn't agree with it. So I sent over a copy yesterday for him to review.
My understanding is during the hearing, you indicated you agreed with the interlineation. All it did was add remedies if there's a violation.
Well, the remedies are clear. I did not agree with your interlineations. I said that very clearly on the record, but I did put in something to the effect of what you had in that paragraph. I did not agree with that paragraph.
Okay, so what I have is for paragraph 3. So before we go any further, I want to see, I have Nicole Tideman on here. Is that correct? Can you turn your camera on, please?
Sorry, Your Honor. I just heard you.
Okay. I just want, this is the final matter, and I just want to make sure that nobody is waiting for something else.
I am not, Your Honor.
Okay. All right.
And Your Honor, I see that Miss Acevedo, is she still here or did she leave?
No, I think she left.
Yeah, she was number 7. That's been handled.
Okay. I just want to make sure somebody doesn't think that there's something else on here because this is the final matter. And Sherry Evald.
I'm just a GAL observing.
Okay, thank you. I think we're good. Okay, so let me go back to what we were doing here. So I have for paragraph 3, violation of this order may subject the violating party to fees, costs, and other sanctions as determined appropriate by the court after hearing from all parties on any motion for such relief. That seems like an appropriate paragraph.
And I think that kind of paraphrases what I had put in.
Okay. So
that's why I did it the way.
Okay. So I'm going to put approved via Zoom, Mr. Anagnostou, for you. Is that okay?
Yeah, that's fine.
And I had sent over a signed copy yesterday.
Yeah, I'm signing that order here. So last week, I ordered the full compliance with the interrogatories and requests for production, and that it was to have been done because my understanding was that everything was ready and ready to be sent over with the protection order. Or the protective order. I put the protective order in place and to apply to both, and I expect the parties to comply with that. My understanding is what Mr. Anagnostou had was a set of documents, and that I had asked Ms. Cotto to put together a list of the items that she finds that she did not receive, which is what she did. And so now what I'm hearing are objections as to why they should be having to do it. My problem with this whole thing is that this should have been done long ago. Is the trial still set or not?
Well, I'm going to be asking for continuance because clearly I will not be ready.
Okay.
It's set for the week of March 11th. I just got served with the R904s. I can't even do mine because I can't be ready. So I'm going to be filing a separate motion for that based on the discovery violations. I just didn't have time in the week because I expected to get everything.
Well, and that's where it seems, I wanted to see, I was hopeful that what was requested would be turned over. It doesn't sound like it. So that's what I was looking at. So it seems like that's what needs to happen now. Is you need to file your motion and we go from there, and then Mr. Anagnostou can respond however. But meanwhile, with what day is that set for?
It's set for the week of March 11.
Okay.
So, Your Honor, I just want you to understand, I haven't had an opportunity to respond to the documents Ms. Cotto served on me yesterday, and I disagreed. We have answered. We have provided bank records. We've provided med records that were requested. We've provided everything, and they don't like them. They don't like the pay stubs. I mean, we provided years of it. We provided a tax return that shows what our income is. But yet we're still fighting, nitpicking about this because they can't win on the facts. They're going to just pummel my client procedurally on these discovery questions. We've answered everything.
My problem with the whole thing is that, again, this should have been done a long time ago, and your client failed to turn in the documents. And here we are right before trial, and whether what Ms. Cotto is arguing or not will be looked at, but to be right up against trial, which shouldn't have happened, is not appropriate either.
Well, there was a week delay because she refused to sign the protective order that she prepared.
Okay.
We heard this last week, Your Honor.
Yes, we did. So in regard to the request for the continuance, anything further on that, Mr. Anagnostou?
It's not properly before the court.
I can do a written motion.
Okay.
I'm going to ask for terms today because, again, it isn't that I don't like the answers. It's because the information that I'm asking for is very relevant.
I haven't had an opportunity to respond.
Is very relevant to trial. I've kicked out anything that I could live without for trial, but I can't do it without this information.
She has subpoena power.
In Idaho, I do not. Most of the documents I want are either through the federal government, which is the Veterans Administration. They will not honor a Washington subpoena. We've already gone that route quite a while ago. But in the meantime, had Mr. Anagnostou's clients answered it in time, I would have been able to follow through with whatever I could have followed through. Idaho, I don't have subpoena powers. I'm not licensed in the state of Idaho, so I can't get Idaho records.
Had she signed her protective order that she prepared, she would have had them a week in advance.
Well,
okay, enough. So bottom line is that we're going to be right up against trial. Write a formal request. We'll address it then. But the problem is, without me just going through the records in detail to know, and so it seems like we almost need to have somebody appointed to go through the records, which that's what I'm looking at. So that may be the next option that we have to look at, is having somebody appointed to make a determination.
A discovery master, is that what you're thinking?
Yes. I don't know what else to do. It doesn't seem like it's that much. At the same time, it does. So what I'm going to do is I don't know if you want me to actually just set it over, if you want to note it up. We could do it next week, but I'm afraid it's going to be too short of time.
Are you gone next week? That's what
No,
okay.
I'm not. I had that messed up as to the date.
Okay.
I'm out of state next week, Your Honor.
Okay, so
2 weeks.
2 weeks.
Okay, I will, I have a trial set in juvenile tomorrow that may be going, so I will do the best I can. If I can get it done by tomorrow, I will try.
Okay.
I'll just make it for the record very clear. It is based on the multiple discovery violations.
Yeah, and I understand that, but again, going back to the special master on this, meanwhile, I'm going to try to look and see who we might have available. I'm not sure who's been acting in that capacity here. So I'll work on that as well.
Okay, and then when you appoint.
Just for reference, Your Honor, I have seen Mr. Ammons appointed as a master on a couple of cases that I don't know about.
This is the problem with one here and one there, but let me hear from Ms. Cotto.
I would just like to see who the court's considering, and then we can communicate with the court, all parties included, via email saying, yes, we agree with that. And then we would also like to know the cost. My client is on a fairly limited income.
Yeah, and that's the other thing. I just don't even know what they're charging right now. So
you had to use one before.
So if he has some ideas of who, and I'll try to talk to administration and see who they may have as suggestions as well. So I wasn't thinking of Mr. Ammons. That's a possibility, and see who else might be there.
Okay, and then I'll make my formal request for the motion to continue, which I'll have filed with the court. Is the court doing any orders today so that I can make sure the record's clear?
I don't think I need to do any. I'm not taking any action today, bottom line. So just file your formal motions and then we'll go from there.
And reserving any requests and any orders. I also submitted an order from last week. And I served Mr. Anagnosto again. I served him yesterday due to the short turnaround and all the other stuff that I had to do.
Had a time to review that proposed order, Your Honor.
All right, let's couple weeks out, just bring it up again. I'll just leave it in here for now.
So the order over 2 weeks, along with the motion to continue and reserving any rulings on any further sanctions.
Correct.
Okay.
And consideration of the special master.
Okay. Does the court want me to do an order or just leave it in the clerk's notes?
Clerk's notes are fine.
Okay. I'll just make sure Madam Clerk has that.
Okay.
All right.
All right.
Thank you.
That concludes the matter for today.
Thank you, Your Honor.
All right. I still see another. I'm going to end the session.
Ms. Farr, looks like you're involved in this one.
Yes, Your Honor.
And I believe this was on for approval.
So we were waiting for the CPS information. I received an email from Ms. Maddox that the CPS information has been filed. I haven't received it yet, so I haven't reviewed it yet. As soon as I can get a copy and review it, then I can file my report and we can finalize the final order.
It looks like it actually made the court file January 23rd. It does look to be clear from everything I can see.
Okay.
So how much time do you think we'd need per report?
I think a week. I think we could get this entered next week.
Okay. Is there anybody else appearing on this matter? The grandma's here, Teresa. Good morning. Are you available next week at the same time?
Yeah, that's fine.
Okay, so we'll get a report filed and then I will need some final orders, which I believe I've seen, so.
Yeah, Miss Maddox sent me her proposed, and then I just need to add my edits to it, and then we can use that.
Perfect. So we'll set it over 1 week, and that would be till 10:30 on the 20th. And we should be able to have final orders entered.
Yes, thank you.
As far as this is okay. also yours.
Thank you.
Thank you. And I think, do we not have CPS on this one? I don't think we do. Have you seen that yet?
I'm looking, give me just 1 second and see what I've done to start this one. So I was appointed in December. Okay, so the father is not identified on the birth certificate.
Correct.
And there's still some outstanding things for the petitioner to do, the declaration of training, the CPS response, and I have not spoke with the mother yet.
Okay. The other thing I was going to mention this one is this is still an emergency guardianship, so if it's planning on going farther than 120 days, we would need a full guardianship filed.
I'm looking to see, does not look like the standard petition has not been filed yet.
I'm still working on it.
Okay. Perfect.
And I'm mom and I'm in agreement with everything.
Oh, okay.
Yeah, Brood Mom has consented, so it's a matter of just getting all of our ducks in a row as far as paperwork and then getting if it's going to be going longer than 120 days, then we'll need that full guardianship petition. So what are you thinking about timeline?
So Ms. Lopez, will you and I need to schedule a time to talk as soon as possible? And then if everything's agreed to, and seems like we should be able to get this done in 3 to 4 weeks, do you think, Your Honor?
If we think the CPS information will be back by then, I could maybe put it out to the 12th of March at 10:30.
Let me just check.
Is that a good date for everybody?
I actually am in trial on the 12th and training on the 19th. So
what if we try
maybe the 5th? It'd have to be the 5th or the 26th.
Let's go the 5th of March. I don't want to go out quite that far, I think, at this point. So we'll put it up for review on the 5th, and I'll do an extension order. I lost my pen here just a second. All right, I will get that order entered, and then we'll be back on the 5th.
Thank you.
All right, thank you.
Thank you.
You're welcome. And this looks like it's on for a request to serve by publication. I know we've got there's a service issue on this one.
Your Honor, John Sasaki, representing the mother, Candace Jones.
Good morning.
And good morning. I was just appointed about 10 days ago and have had a chance to speak with my client, Candace, and we would be able to consent to notice and service by email. I just have to get that agreement typed up and provided to the rest of the parties.
Okay. So I was just going to mention that service by publication is horrendously expensive. So if we can go that route, that probably makes a lot more sense. How much time do you think you'll need to get that all in place?
I can do it this week.
Okay.
Yeah, no problem. If not today.
Okay. And Ms. Turnbull, good morning.
Morning.
How much time are you anticipating needing to be able to move forward on this one?
I was just waiting until service was completed.
Okay.
And I should be ready.
Okay. So it sounds like we can probably start moving forward with the understanding that'll happen as soon as we get all the paperwork in place, it sounds like.
I didn't, Your Honor, I'm so sorry. I didn't hear what Mr. Sasaki had said about at the first, the computer sort of cut out a little bit.
Sure, they're agreeing to accept service via email, but there's a document that needs to be filled out in order to do that, and he's going to prepare that and get that to you.
Okay,
So I won't be ordering the publication. It'll just simply, we've got a little different, it's an email version, but it'll have to go through some channels. It'll take probably a week or so to get that all sorted out. And I don't know, I didn't see the CPS information on this one yet. Let me
I
check.
don't think it's come in yet.
Yeah, it has not come in yet. And then Ms. Turnbull will need to have discussions with everybody involved. At this point, let me see here, order extending. I could probably.
Right. I do have one other preliminary question, in that if the court would allow it and all the other parties were of the same mind, my client and I wanted to offer the possibility of possibly proceeding as an adoption rather than a guardianship. Would the court be open to that option if the parties agreed?
And let's see, our petitioner is Teresa Lee, so.
the thing is she's 16 years old, and the only reason they would want to do option is responsible for anything. They haven't been responsible from the beginning. That's why and if there wasn't a spot on those papers that said that about child support, they would have signed the papers already, but now neither one of them want to pay child support. I don't care about the child support. It can go directly to Rainey. She wants to be a pediatric nurse. I don't need their money. It's not about that for me.
Okay.
At all.
Well, let me stop you for a second there. The issue of child support is, I guess, really more an issue if the state is involved, if there's no request. I mean, I don't know that that's something, but that's, again, I'll have to see what Ms. Turnbull says about that. There may be some other options. But again, those are discussions that could still be had, I'm sure.
Yeah, I'm not trying to, I don't care about all that.
But on the short term, we need to make sure somebody's able to take care of her needs, so.
That's me, always.
Okay. So do we want to set this out maybe about 3 weeks as well?
However,
that would be March 5th.
March 5th, I could, that'll give us time to get all the paperwork kind of in place. Ms. Turnbull an opportunity to look into things. Hopefully we'll have our CPS information and we can have discussions about how we want to proceed.
That sounds good.
That would work for me if it works for everybody else.
Yes.
Okay, we'll put it on for 10:30 on the 5th.
I'm sorry, I lost you. I can't hear you.
We'll put it on for the 5th of March at 10:30. I'll do an order extending the existing order to that point.
Thank you.
In your honor, before concluding, if I have Mr. Wittick's permission to obtain his email, I haven't been able to get his email to include with the agreement of service by email. Would it be possible to send us to a breakout room to exchange that information?
I can do that. Are you comfortable with that, Mr. Wittick?
Yeah.
Give me just a second. This was on for review of the motion to compel. Did you get what you were looking for?
I have not received any discovery.
Let me see here just a second. Looks like a response was filed 2/6.
That is correct, Your Honor, and that was a response to the petition about dissolution of a marriage. That was not in any relation to the discovery.
Okay. All right, so I don't see him. Hold on just a second here. Oh, he's in just a second. Looks like he is on the way, just logged in. Mr. Gall, can you hear us? You're still, there we go.
Yes, I can hear you.
All right, so this was set over to review compliance on some discovery. It sounds like that has not been completed. Is that accurate?
Compliance on discovery? No, Your Honor. To be honest, I'm surprised about this hearing. My understanding from the Guardian ad litem is that She was to give you an update on her efforts with their reports, which is Ms. Corey. So I
Your
don't know.
Honor, this is not the,
That's a
res-
different
I'm,
case.
Hey,
yeah, this is a different matter, Your Honor.
counsel, please don't interrupt when someone else is talking. Go ahead, Mr. Gall. I couldn't hear what you were saying.
So Ms. Corey is here to give the court an update of what's going on. I had no clue that there was a discovery issue at all, Your Honor.
All right, well, Miss Corey had indicated that this would just be over a week due to some issues, which is fine on that issue.
Yes.
When we were here last, which was, just a second here, on the 6th, we set it over to today on the motion to compel because there was some information that you were going to provide at the end of last week.
Yes, Your Honor. I'm actually still waiting for Ms. Corey's report and the reunification counselor's report as well to submit for that, Your Honor. So that all that information is not yet complete for me to present to the court. And to be honest, Your Honor, Commissioner Kearney made it sound like that I needed to reapply for that hearing and that she was not going to allow for what you are mentioning to be heard. And I'm very happy that it is allowed to be heard. But I'm still waiting for information from the reunification counselor to submit to the court. There's been some drastic changes, and apparently, Your Honor, the guardian ad litem was supposed to provide you an update with their efforts, and there's a medical emergency with the children.
I understand that, sir. This is a separate issue. This has to do with the discovery request that we were on, I believe, on the 6th, from a motion to compel discovery.
Your Honor, if I may interject, Mr. Call is not the respondent in the motion to compel. That would be Mr. Fowler.
I'm sorry. Thank you. All right. So is Mr. I apologize. I got the wrong thing. So just hold on a second, Mr. Gall.
Understood.
All right. So, counsel, what did you want to do today then?
I would like to impose the sanctions pursuant to 37A and B on this matter. I would also like to have another review hearing in the event that we do not get a motion for default that we have on the 20th.
So it looks like you were requesting 1,500 in fees, is that right?
Yes, Your Honor. And if we could, due to the fact that I have to appear again today, I would like to increase those fees if that is possible.
All right, I'll order 1,700 fees. And you want to set it, when do you want to set another review?
The motion for default that we have is set for the 20th of this month. Because Mr. Fowler did appear at last week's hearing and he has put in this response, I anticipate that I will be withdrawing that motion for default. But Your Honor did set a presentation of orders on this for the 20th, so we will hold that hearing date. I think it would be appropriate to set out discovery another 2 weeks for another review hearing.
Well, why don't we set it both? Let's put it both on the 20th and we'll review it next week then. And then if we want to put it up farther, we can. I don't want to set 2 more hearings. If we still have presentation on for the 20th, let's leave it on for that.
Absolutely, Your Honor.
Okay.
Thank you. Honor, one last thing before you switch. Mr. Fowler, it appears, is back in rehab. Is there any way we can also include in that court order on the motion to compel for fees that my client is allowed to pay the fees on behalf of Mr. Fowler out of the joint checking account?
I'm fine with that.
Okay, thank you, Your Honor.
Come back to you real quick. Ms. Corey did appear indicating there was a medical emergency and we were going to set this over to next week, and apologize. I was a little confused earlier. I was looking at the wrong.
No worries.
So we'll just put it over to the 20th at 1 o'clock.
Thank you, Your Honor. And Your Honor, may I ask, I don't know how the court notifies people, but I provided my email and my address. How can I be made aware of these hearings? Because I was not aware of today's hearings, Your Honor.
This one was noted on the order appointing guardian ad litem.
Got it. So I must have hung up too early, Ms. Corey?
Now, if you look on the order appointing Ms. Corey, there should be 3 dates on there. Today was the first one of those days, and we're setting today over to next week. There should be 2 more dates on that order.
Correct. And then the final due date is a 20-something of April, correct, Your Honor?
I don't have that in front of me, but I believe so.
Okay. And yes, Your Honor, to be honest with you, I was a little disheartened when Commissioner Kearney disallowed my rescheduling of a faster trial date, noting that I didn't have good cause. And
All right, well, I understand, sir, that you can address that at a different time. This is not the time for that.
All right. I was just addressing the confusion, Your Honor, so thank you.
Okay.
All right.
That's all for today. We'll see you next week. There's, I see Ms. Green is present on Zoom. I have Mr. Zandy is present in court, and I believe I saw.
So my client is on the Zoom meeting as well, Your Honor, Kelly Powell.
For some reason must not have their camera on. Just a minute here. Okay, I see Kelly Powell is present, and I believe I saw the mother. I'm not seeing her now. Ms. Green, was your client planning on attending today?
She was planning on being here. I don't see her on the list either. I'm not sure if there was an issue with her attending. So
I've got a couple of people in the waiting room listed as observers, which would not be normal. I have an El Marie and an Amy.
Amy would be my client, Amy Powell, and the observer may be my legal assistant.
Okay, well, observers should be observing via YouTube. So, all right, so this is on for adequate cause hearing as well as temporary orders. And I believe, Ms. Green, this is your motion.
Yes, Your Honor. So my client, Amy Powell, now Amy Rieger, has filed a petition to modify the parenting plan because there's been a substantial deviation from the prior parenting plan that was entered in 2021. So at the time the parenting plan was agreed to, the parties are still residing together. And it wasn't until my client moved out that the parenting plan would go into effect. At that time, when my client did move out, the parties agreed that my client would still have the children when father was working his night shifts. And so that has been the agreement and a substantial deviation from the parenting plan for some time. In fact, if you review Mr. Powell's declaration, he clearly states that the current parenting plan has been working out, but the current parenting plan has been my client taking over the 2 nights that he's working graveyard shifts and the following day so that he can sleep, which is what he had asked to occur. So my client is asking just to adopt the language change into the agreed parenting plan that for those dates where father is working those graveyard shifts and that following day when he's sleeping, following his graveyard shift, that the children remain with her. This has been the ongoing parenting plan for several years now. This has been what has been done by agreement of the parties. It seems that Mr. Powell is only arguing because he's afraid of the change in child support, which is the main issue he keeps bringing up. It hasn't been that this parenting plan doesn't work. It hasn't been that he hasn't agreed to this parenting plan. It's merely his argument that it's going to change child support and he doesn't want to change the 50-50 schedule for that reason. So my client's asking that the court find that there's integration. There has been an agreement that has gone on for a period of time. The boys were 9 or now 11, and the concern is that the children at that age should not have been left alone, home alone with father working and no one supervising. So this is what they had come to. My client is only asking to codify it and put it into the parenting plan so that it can continue to follow going forward for these children. Additionally, the other change is that the eldest child has aged out, so she's no longer necessary to be on the parenting plan. And that is the reason my client is concerned about not having the court grant adequate cause and making this change. Additionally, because it has been 3 years since the parenting plan and child support order were entered, my client is asking for modification of child support based on their new incomes. The basis for child support previously was my client's understanding was that it wouldn't occur until she moved out. Obviously, when they got to court, a different agreement was made, but she understood that things would change when she moved out. And now that she's been out of the house for several years, it is appropriate to modify it. Plus, it has been beyond the statutory time limit to modify child support. So it would be a non-issue regarding whether or not the parenting plan changes if she wanted to change child support based on the years that it's been since it was entered. I do want to bring up that Mr. Zandy brought in a motion, or I'm sorry, memorandum of points and authorities, I believe late last week. I'm not sure if the court is referencing it or relying on it. I do have a couple of concerns with, first of all, its untimeliness. It was provided after we had already filed our reply and substantive bench copies. Additionally, Mr. Zandy refers to the Cowlitz County Local Court Rule 93, but he does not provide the current and updated version of that rule. He relies on it stating that the parties are required to go to mediation before attempting any kind of modification of parenting plan or changes. But the current court rule actually says that mediation under 93B, mediation is required unless prohibited by law. All custody or visitation disputes shall be submitted to mandatory mediation before proceeding to trial. So it has nothing to do with temporary orders. In fact, Mr. Zandy cites 93C, which currently states that continuing superior court jurisdiction, the requirement of mediation shall not prevent a judicial officer from entering temporary orders. So my concern is Mr. Zandy seems to want to mislead the court that mediation was required. The parties needed to go to mediation. That is not the current Cowlitz County rule. That is not the requirement in the parenting plan. It says specifically they can go to court. And my client has had the burden of paying for this and having to do additional research in regards to Mr. Zandy's false and misstatement of the court rules to come to court today and make sure that the court is fully aware of what is actually the statutory requirements under the Cowlitz local rules. So we do want to bring that to the attention of the court. Additionally, the basis for modification, we believe, has been met. There's been a change in circumstances. My client has moved out. Yes, that was contemplated, but my client taking over father's days when he's working was not contemplated until they moved out and figured out it didn't work. So the parties have agreed to the substantial change. It is appropriate to modify the parenting plan in the child's best interest, and it would seem to keep the continuity of the current parenting plan would be in the children's best interest. So all we're doing is asking to adopt what is already happening. The fact that father is objecting is pretty problematic considering he has taken the benefit of this schedule for several years now. Additionally, we did ask for fees if it was litigated for the basis of having to argue this. We think it's a non-issue that should have been just granted as adequate cause and move forward to finalize the parenting plan as the parties have been doing for several years. That is all, Your Honor.
All right, thank you, Mr. Zandy.
And I think Your Honor's court's aware I do represent the original petitioner in this, the non-moving party, namely Kelly Powell. Although I certainly appreciate the efforts related to the adequate cause and the comments about mediation, which I'll get to here in a moment, those, again, do not comply whatsoever with the statute as well as the case law. I'll begin by stating we're talking about two kids here on the verge of turning 12. That's Sean and Robert. Both parties are excellent parents. Both kids are very good kids. They're doing well socially, academically, extracurricularly, and everything else. I would start by stating that these parties, for the better part of several years now, or at least since their separation, which predates the divorce, have done very well in accommodating each other's schedules pursuant to life changes, which they both admit to. My client doesn't deny that. That's exactly what the court wants parties to do. The parenting plan is there if the parties cannot agree to do something else. These parties, as both seem to admit, mom is somewhat silent on the issue, but my client details for you. If they need to change some time here or there, they readily do that. That goes both ways. And again, the parenting plans are somewhat of a flexible tool to put parties well on their way. And these parties have done very well. Again, if you look at my client's declaration, there's no dispute on this. I think it's agreed both parties lived together for a period of time after separation, both prior to divorce being final, and my understanding is after the first brief period as well. These parties have still socialized together. Mrs. Rieger, in fact, contacted my client around the holidays of this year, said, I've got a new romantic partner. I'd like you to meet this person. They go out and have a dinner or a drink or some kind of a social event where they sit down, they meet, and they discuss and they talk about the kids in life. We don't typically see that. A couple of days later, a few weeks later, they celebrate Christmas together with the boys, with Miss Rieger, with my client, and with the new individual who Miss Rieger is actively involved in. We don't see that at all. So again, both parties should be credited for being able to do that when the vast majority of people on this docket and outside of this docket are simply unable to do that. These parties, again, have talked about life. They've talked about things. They've impacted the life of the boys positively. Both kids are doing well in school. I believe it's one of the kids, Robert's, not doing quite as well as Sean, but that again is a mere technicality of how well these parties are doing and how well the boys are doing. These parties live about 5 minutes apart. My client lives in Lexington. Mrs. Rieger lives in North Kelso. Again, that's by design over the course of the past couple of years. So again, they can accommodate schedules. Both parties work. That's terrific. If she needs him to pick up the kids a little early, great, and vice versa. And again, everything they've done up until this point is exactly how the court, exactly how the mediators, exactly how the specialists would want them to behave, and that's what they've done. Fast forward, and this is the part where it's somewhat frustrating from my client's perspective. I'll talk about the local rule here momentarily. These parties are doing well. They celebrate the holidays together. Then all of a sudden we start getting a noise from Mrs. Rieger about child support issues. I need more money. My client, unbeknownst to him, I get served again randomly with the petition to modify the parenting plan. I'll talk about adequate cause and change in circumstance here momentarily. But from a factual position, we're taking two people who have done extremely well, who have worked inside and outside of the orders, again, completely appropriately and exactly how the court would design it and draw it up. So then all of a sudden springing a petition for adequate cause in which she's attempting to take away at least 25% of dad's time. If you look at the petition, again, it's interesting. If you look at the declaration for adequate cause and temporary orders, it's a paragraph and a half, basically of unsubstantiated self-serving commentary provided by mom, which again, my client unfortunately believes is aimed at the fact that she wants more child support. What's the only way to do that? Only way to do that is to modify the plan because it's been a week on, week off. And again, that was set in motion back during the initial report. I was somewhat concerned and confused. Mom provides statements from the court at the time of trial. Ms. Day, who's the GAL, is included in that. Commissioner Busby is included in that. Everybody knew. And clearly a parenting plan is for when the parties don't live together. And that's the basis of a parenting plan. These parties went through the entire process, agreed that it was in these kids' best interest, then aged, I believe, 9, that they have a week on, a week off, 50-50 joint. My client details for you. And again, we're grasping at straws for adequate cause. My client has been employed at West Rock for 24 years. He's had the exact same schedule for 23 of those years. That's what we typically see. 4 on, 4 off, 2 days, 24-hour period off, 2 nights, and then 4 days off. Parties knowing that both of these people are very good parents, very capable and competent parents, agree to go, let's just do the week on, week off, as opposed to a 4 on, 4 off, or as opposed to some other schedule. They knew the circumstances. Back in 2021, my client had the same work schedule for almost 19 years. He now tells you I've had the same work schedule for 23 years. So if we look at the pattern and the history of this, these are parties that have done exceptionally well. The kids are now on the verge of being 12. As they age and they grow in their years, obviously they're by design seeking more independence. They're capable of more time outside of the purview of mom and dad. These kids are blessed because, as my client tells you, they've got extended family in the local area who's bonded with the kids. This has never been an issue until mom decides, again, as she's taking on a $2,000 per month townhouse, that she wants more support. The petition to modify is just a means so that she can again seek more support. If you look at their proposed parenting plan, again, you glean some information from that about the motive of mom. She states, well, we can keep things joint, wink, wink, but when dad works, I want the kids. Well, again, dad works 4 out of every 8 days. That frees up 4 days for him, but he's working 4 12s essentially. His weeks are defined by 8 days per week as opposed to traditional 7. Again, it's the same schedule he's always had. It's the same schedule that GAL this day contemplated. The same schedule these parties contemplated 4 years ago upon separating and then upon eventually the divorce being filed. It's the same thing that's working for the boys. So again, why are we disrupting that apple cart now? It ain't broke, you don't fix it. And this is not broke. These parties are doing what they're supposed to be doing, even if it was an issue. And again, you look at the verbiage in the petition in which mom says, well, potentially it's dangerous if a stranger came to the door and the kids answered it. Well, that's not a change in circumstance, but that's something that's being assumed in the future that has never been an issue, and bad things could happen, certain bad things could happen in the parking lot or anywhere else. That doesn't satisfy the statute as to a change in circumstance or a detriment to these kids. That's from the factual standpoint. Supply those facts, and again, it's largely uncontested. We get no information from mom. The burden is on her to satisfy the statute. The burden is on her to satisfy the case law. She hasn't done that. She hasn't provided you an ounce of information that shows, and my client disputes that she's actually seeing the kids and spending more significant time with them than dad is. She just simply vaguely alleges that. That doesn't satisfy the statute. Counsel in her argument says, well, I don't know that the memorandum of law was timely. As litigators, we're free to always argue the law, and whether I choose to do that in pleadings or whether I choose to make those arguments today, it puts us in the same position. And again, I think that's probably because counsel knows what the law is and knows that this is a significant stretch of what I quoted in my memorandum. We look at what is there. Again, I think the facts are largely undisputed. I've cited case law for you. I've also given you the resources in the statute of RCW 2609-260 plus 270. I think it's abundantly clear. We've cited you to the McLaren case as well as the Hall case, which again, very clear on that. And to all of those and to a man, no state, the court is generally disfavors modification actions, especially in this case. What's the substantial change in circumstance to the children or my client? There isn't one. It's the same schedule that they contemplated again several years ago, the same work schedule that my clients enjoyed for the past 23 years, especially during the divorce. Nothing has changed. Are these kids struggling in any way? No, and that's not even alleged. The only allegation is the fact that if they answered the door to a stranger, that could present a problem. And the fact that these parties have, to some extent, we don't know what, because it's not specified in mom's pleadings as required by the law, to some extent, these parties have gone outside the parenting plan from time to time. And again, that's not uncommon. That does not give rise to a substantial change in circumstance, which again is defined by the case law. Mom doesn't meet that. If you look specifically at 2609-260, it states the court shall not modify a prior custody decree or parenting plan unless it finds upon the basis of facts that have arisen since the prior decree or plan or that were unknown to the court at the time of the prior decree or plan that a substantial change in the circumstances of the child or the non-moving party and that the modification is in the best interest of the child. We don't satisfy any of those, and they're all required for the court to find adequate cause and issue them. Go further. RCW 2609-270 again states in part, a party seeking a temporary custody order or a temporary parenting plan or modification of a custody decree or parenting plan shall submit together with his or her motion an affidavit setting forth facts supporting the requested order. The court shall deny the motion unless it finds that adequate cause for the hearing in the motion is established in the affidavits. And again, that's why the petition is important. That's why the declaration is important. You look at those two aspects of that. The petition is completely void of anything. It again talks about a stranger who may knock on the door in the middle of the night and the kids open the door. They're now 12. This wasn't an issue when they were 10. That's odd. She also says, well, I've been having the kids during overnights when dad works. That's partially true. I don't think that's a uniform. Okay, every overnight dad works, the kids are with mom. That also doesn't contemplate the time that dads have the kids over mom's time. And again, what I just cited requires her to prove beyond just a loose comment that that is actually what's happening. We don't have any of that. We don't have calendars. We don't have third-party witness declarations. We don't have anything that confirms that. My client disputes that, says that's not entirely correct, although it's correct in context here and there, just like it's correct in context that he's had the boys over her otherwise. And again, that fails to satisfy the statute. So I think from an initial threshold of adequate cause, this doesn't come close. To assume and take the somewhat arrogant approach from Ms. Green that, well, there's this adequate cause, everybody should just agree, and therefore, if you don't stand up to the bully, I don't want attorney's fees, but if you do, I do want attorney's fees. Again, that flies in the face of reason. And the comments that she makes related to the statute, again, completely off base when it's clear as day. We've cited for you the McLaren case, and again, the same thing. To overcome the presumption against the modification, the moving party must set forth facts and provide supporting evidence. Again, that mirrors the statute I just read. Not self-serving or conclusory statements to establish adequate cause to schedule a hearing on the petition to modify. Trial court considers and weighs the facts by the parties in the affidavits, by the evidence, and other factors on a case-by-case basis to determine whether the moving party has established adequate cause to hold a hearing on whether to modify the parenting plan. That's a recent case. That's from 2019. Again, we've given the citation for that. It's clear that we have present today. Now, speaking of the mediation, and again, that the court is well aware of how this has been problematic over the course of the past 14 months or so since it was entered. don't disagree with counsel that there is moving parts to that. It was amended in September, but the basis of the rule and the heart of the rule applies directly to this case. And again, we've cited that for you. I pulled that off and I looked again before court today because I anticipated she was going to make an argument like that. Rule 93 still shows up on the county website. It's still exactly as we have just described it in my memorandum of law. It's still applicable. We still have to apply to it. If ever there was a case for mediation, and not every case, and again, the court knows my position on this, not every case is ripe for mediation out of the onset of a case and filing, this would be one that is. Again, this is a case where these parties have gotten along without mediators, without court intervention, without problems. The communications have always been friendly and good. Rather than seeking out mediation and alternative dispute resolution, she pays whatever she pays for a retainer for her counsel, pays whatever it is that she pays for a filing fee, a service fee, and rushes this into court. Again, not based on the well-being of these kids, because these kids are doing great. She does it because there's an alternative motive, and that is the child support. This is a case, and this is the rule that the court set in effect under the emergency order from last January of 2023, which directly applies to these types of matters. This is a case where we should not be here arguing this. This is a case where these parties outside of counsel, because they do get along well, should have went to the mediation service, spent the $300, saw if they could agree to something, recognizing that they're both good parents, recognizing that these boys are both doing very well, and trying to resolve it outside of this. Now where does that leave us? Now that leaves us in complete distrust with one another. My client, who tells you in his responsive declaration how surprised he was and somewhat floored to be served out of the blue after just celebrating Christmas together as a family, to be served with this with very generic allegations. And again, what does the case law say? Self-serving. That's what mom gave you, was self-serving information. They're geared towards whatever her motive is. One can only assume because she was asking for more money, and she's asking for nearly 3 or 4 times the current child support amount to be awarded, that she's driven by the financial resources of this. So again, this is a case that absolutely, even if the rule didn't exist, should have went to mediation. But here we are, and the rule does exist. That rule is still on the county website. It's still in effect, whether it's been amended or not. The gist of that, the tone of that, and the intent of that is still the same. It's exactly as we quoted in our memorandum of law. So for counsel to allege that something is misstated, for counsel to allege that somehow I am trying to provide the court when your honor is the one who had partly drafted this, again, is completely disingenuous and somewhat offensive. We kind of expect that from Ms. Green, but nonetheless, here we are still arguing this. And my client, pursuant to statute, is entitled to fees. There is an adequate cause. They didn't comply with the mediation standard. My client spent $5,000 on a retainer in my office. I haven't gone through all of that. And you'll see in my memorandum that it was about $2,500 to get through to this stage. We're asking that he be reimbursed every penny. This is brought in bad faith. This is brought contrary to the law. It doesn't comply with local rule 93. However, counsel tried to dance around that. And we're here when there should have been other resources that were taken as opposed to doing it the old fashioned way. That's our position. We do think the facts of this case are, and they're unique in a good way, because we've got 2 people who are doing very well. We've got 2 young men on the verge of teenage years who have done very well and love both mom and dad. That's paramount. That should be the concern. And again, cases like this, the law specifically states, or shall be denied adequate cause.
Thank you, Ms. Green. Response?
Yeah, Your Honor. So I particularly looked up the rule, and it is on the website for the Cowlitz County local rule. I'm not certain why there's some disagreement when it says that the rule is from the 2023-2024 year, that there is something completely different between Mr. Zandy's understanding and mine. But at this point, regardless, the version of the rule that I have says that mediation is only required before trial. We're not at trial. We're at temporary orders, and it specifically allows for temporary orders to be entered without mediation. Regarding reviewing the statute that Mr. Zandy brings up again, 26.09.260. Yes.
Hold on 1 second.
Local rule CCLCR 93, subsection D, upon the filing of a response to the petition, which we did, which contests a parenting plan, which it did, child custody or visitation, making the proceeding subject to these rules, the petitioner, that's Ms. Green, shall immediately note the proceeding for mandatory mediation. Subsection D, Ms. Green.
All right, Ms. Green, go ahead.
So again, when I reviewed the rules, it says that in C that the requirement of mediation shall not prevent a judicial officer from entering temporary orders. So if that is misstated, then I don't know what else to do, because at this point we're asking for temporary orders. And so moving on from that point, going back to RCW 26.09.260, it says that unless it finds upon the basis of facts that have arisen since the prior decree or plan, the facts that were presented, and in addition, Mr. Powell's declaration states that he had various family members in the local area that could spend overnights with the boys and would be willing to do so. He does not state that he didn't agree with Miss Rieger taking over the children during his nights that he wasn't able to take care of the children. It's clear he's not home, the children are young, and he agreed that Miss Rieger would have the children during those times. It was in their best interest, it was the agreement of the parties, and it happened after she moved out of the house. So all those facts support the agreement made between the parties that she would have the children during that time. It shows clearly that he did not attempt to have anyone else take care of the children. He relied on Miss Rieger to do so, and that was the agreement made. The substantial change that has occurred, my client moved out of the home. That changed the parenting plan because now there's not two parents home night and day to take care of the children. While it was contemplated, the actual effect of it showed that there was not someone home during the week on, week off to take care of the children when father worked. That was a substantial change that occurred, requiring my client to take over additional time during father's time. There's no quid pro quo. They didn't make up days or differences. She always had the children when he worked. That was what he requested, and that's what she did. And that the modification is in the best interest of the child and necessary to serve the best interest of the child. Obviously, it was in the best interest, and the parties agreed that mother would take care of the children when father worked. I don't know what else is required to show that this is in the best interest of the children. Mr. Zandy argues the children have been doing well. Well, it's probably because they're not left home alone with nobody watching them 2 days a week when they're with their father. It's probably because they came to this agreement to make sure the children were taken care of. Someone can help them with their homework, that there wasn't a something to harm them because they're left at home and there's no one there to supervise if something bad were to happen. I know that those are what ifs, but the best interest of the child is continuing the same schedule that they've had. We're not asking for a change. We're asking to put into place the parenting plan that they both have agreed to since my client moved out of the home. I have nothing else to say. That is what integration is. It's the core principle. They had a substantial change and deviation from the parenting plan they entered, and all we're asking is to codify that. That's all, Your Honor.
Right. Sorry.
Quick rebuttal.
Brief.
And if you look at that, I agree with the integration. The problem is there's no proof of that integration. And the parties disagree on what that was. Certainly, and again, they both agree to certain things on both of their time of packing them. Without a schedule, without any kind of concrete information or evidence as required by the statute, it flies in the face of the reasoning. And at that point, it's self-serving information supplied by Ms. Rieger. And again, that doesn't satisfy the statute. And if the court was to consider that and push for temporary orders, and again, it's contained in my client's response, that a 4-on, 4-off probably satisfies that, gets everybody in the same spot, which you saw my comments on that in my submissions, put you in the same spot, least amount of impact on the kids, and you maintain some structure, which is continuity, which is always in the kids' best interest.
All right, thank you. I reviewed back through this case, looking at the pleadings that were entered, it looks like by Commissioner Busby originally. Both the child support and the parenting plan specifically contemplate the move, so that's certainly not a change of circumstances. The eldest child aging out is not a change of circumstances. Just reading through what was presented as a basis for this, I'm not inclined to find adequate cause on the parenting plan, frankly. This was, I mean, his job hasn't changed, so they know exactly what they were getting into when they did this. So I'm not inclined to make a change at this time. I was concerned about just the level of change that was in the proposed parenting plan. There were significant changes that weren't in the existing parenting plan. I didn't have a basis for any of that in any event, but I'm disinclined to find adequate cause, so I'll deny that at this point.
Please.
And we did provide financial declaration for my client. Obviously, makes substantially less than father did, and at the time that the child support order was entered, it was done with a deviation without consideration for her income. So she's been making a lot less for support than she should have been when she moved out of the home. So I would argue that she is not in a position to pay any substantial fees. This is something that she wanted to get entered to codify what they have been doing. It was not made in bad faith, Your Honor.
I think looking at either worksheet, and I don't know if the current one that was filed as part of this pleading is accurate or not, but looking at the other, I think under the statute, I don't see this as necessarily a bad faith filing, but I'm gonna have each party bear their own fees, frankly, at this juncture.
Yeah, presentation in 2 weeks.
27th at 1 o'clock.
Thank you.
I actually have been trial that day, so can we do the following week?
Probably do it next week. I don't think this is going to be a complicated order. It's just going to say something tonight, I guess.
That should be
I
fine.
need a bench order to that effect.
You want to do the next?
Presentation.
That's fine. If you want to do a bench order that's denied and no fees ordered, that's fine.
I can do that. I'll just put in adequate causes denied and each party to bear own fees.
Very well. Thank you.
Believe that is the only thing we had left on the docket, so we are adjourned.